Mr. Sikhakhane.
Yes, Chair. First, I think it's true that the mission of a tribunal like this is truth finding. But truth finding also must happen within the context of fairness. And that's the key word. And secondly, it must.
May I interrupt you, if you don't mind? One of the things that might just be concerning, if we were to allow that, is that the complainant is cross-examined once and once only. But if we were to grant what you want us to do, the respondent is going to be cross-examined twice. And all the witnesses that the complainant is going to call are going to be cross-examined twice. First by the evidence leader, or second by the evidence leader, and then by yourself. Whereas the complainant is being cross-examined only once. These are some of the things that cause some concern.
Yes, Chair. In fact, the last comment you made, Mr. Matonsala, made this suggestion to me about the expert. He said, can we both cross-examine her? It's true, it's happened yesterday. And I said, no, but that would be unfair to her. You would have, let's see how we field questions together, but it would be unfair to subject a witness to that. And the point I was making right at the beginning is that, yes, truth finding is important, and we must do everything within the law to find the truth. The problem happens when we interpret fairness to mean we must disregard the law, what provides, because we must assume that the rules and the act, the provisions, the relevant provisions in the rules and the act were made with that in mind. Secondly, I would like the panel to look at the case of the Social Justice Coalition versus the Minister of Police. The citation is 2022-10 BCLR 1267. It's a court judgment. It does help us about how do you exercise inherent power. Because at paragraph 81 of that case, you will see that they caution courts about even that exercise, that exercise must be done carefully without assuming jurisdiction where none exists. The power. Now, this is the second time I hear this submission generally, that where there is a lacuna, one is empowered. Where there is an exclusion, because I'm not mentioned that I can't do covert work. I'm not specifically mentioned in the Strategic Intelligence Act. Only the state security is mentioned. I am not excluded because they don't say I'm excluded. But the exclusion is found in who is empowered to do something. That's how I think, and how I think the legality is founded, is what does the statute permit, provides for. That is how a power is established. So it's an inherent exclusion. And our assumption that it was excluded because those who drafted it were being unfair, were not committed to truth or fairness, is an assumption that we shouldn't make. And so we also suggest this, not because the respondent or any of our witnesses fear anything, but we make this suggestion to suggest that the basic point made here, that the exclusion means you are empowered to. We suggest that the court, the tribunal should steer clear of breaching that legal position, that statutory position in its search for fairness. Because in its search for fairness, it must also realize that it's fairness to both sides. I've made this point several times. And I think the prejudice about which we are told that may happen, if any, is mitigated by the suggestion, and I don't think anybody would really reject the suggestion that yes, the evidence leader and the complainant's legal representatives must work hand in hand to field questions that they think the evidence leader has excluded. Lastly, the complainant's legal representatives were aware of this right at the beginning. In fact, I'm going to take you to what my learned friend says on the 13th of January 2025. And I'm not suggesting anything. I'm just saying that they were aware of this position. Page 36. And my learned friend at line 10 says, I will not be leading witnesses. Full stop. That's one line. And it says, I will not be cross-examining witnesses. This is the opportunity that I have to address this tribunal, and I thank you for that. So I'm saying the awareness about the legal position was there right at the beginning. And so we suggest that to subject witnesses to two cross-examiners in breach of a clear non-existence of the power would be unfair. Yes, would be an attempt at truth-finding, but would both be unfair and unlawful. And we propose, therefore, that this can be mitigated and time can be saved if there is permission for the legal representatives to collaborate with the evidence leader to field questions, whatever question they think should be fielded. Those are our submissions, Chair.
Yes, I forget.
Just two things, Chair. The first is just to distinguish between the well-known rule that two people on the same team are not entitled to cross-examine a witness from a situation which multiple teams of counsel are separately entitled to cross-examine, and that we see routinely in our courts. So that's two different situations. And here we have regarded ourselves as a separate team. But I take the chair's point, which is different to what Advocate Sikhakhane is talking about, which is really that the complainant was only cross-examined once and the respondents twice. I accept that point. I can't contradict you. That is true. That would happen. The second point is to say this, is that I'm quoted by Advocate Sikhakhane from the first day of these proceedings. That quote is taken a little bit out of context in the sense that that was absolutely my position. It's always been my position. The rules are clear that we don't have a right to participate. And that's why I said I'm not leading evidence and I'm not cross-examining. But if you read the full engagement on that day, which we refer to in our letter that responds to the respondent's letter raising this issue in the first place, we put the whole section of that transcript in, which is to say, after I raised that, the chair intervened and said, it's your decision as the chair to decide who speaks and who does not. And that was an exercise of that discretion, and then you clarify that we'd be entitled to questions. So I just want to place that context on record, that it's not that I'm changing my position. I've never changed my position. The position has always been that we understand this would be an exercise of your discretion, and that is why we seek your permission to do so. Other than that, Chair, I stand by submissions. This is a decision the panel will take considering all of the factors we've discussed.
Let us adjourn for 15 minutes. We'll come back and give a ruling at quarter to 3. Thank you. To testify, to testify on the respondent, such a privilege and opportunity will be given. Furthermore, we have decided to allow the complainant's legal representative to submit written argument when the time comes in support, if they so wish, of the complainant's case. Also troubling is the fact that if the wish were to be granted, whereas the complainant would be cross-examined only once, the respondent and every single witness the respondent would have called would have to be cross-examined twice. And one wonders what fairness is there in such a situation. But anyway, that's one of the considerations we took into account. That said, in due course, we are going to give full reasons for this decision, so that it becomes fully understood why we come to this decision that we do. The ruling is therefore that the legal representatives of the complainant would not be entitled to cross-examine the respondent and witnesses called at the instance of the respondent. If they so wish, they would, as it were, have to do that through and in consultation with the leader of evidence. That is the ruling. Advocate Skippers, I was waiting for as the court pleases, but
As the tribunal.
I've long left the court, so. Advocate Skippers.
Yes, Chair. I think it's now for the case for the respondent.
Oh, yes. Mr. Sikhakhane.
Thank you, Chair. Chair, so much has crystallized in this case, and so I'm not going to waste time about traversing what this case is about and all the elements. But I want to start with this because there's a lot of mischaracterization that can happen in a case like this. And I'm going to start with what it's not about. And then I'll get to what it is about. This case is not about and has never been about the following: whether the complainant endured inappropriate comments and gestures regarding her physical appearance. Indeed, neither in a complaint nor in this tribunal did the complainant make comment about those claims. The second point is that this case is not about whether the conduct of the judge president contravened or breached Article 5.1 of the Judicial Code of Conduct, which says as follows: a judge must always, and not only in the discharge of official duties, act honorably and in any manner befitting judicial office. It's not the case that was in the notice for him to meet. Second, that all activities of a judge must be compatible with the status of a judicial officer. I'm not saying these are unimportant. I'm saying the case that he came to meet was not this one. And what was the case to meet? And these have no competent verdicts, what I'm about to read, which is the case that was presented for him to meet. And it's found in Form 2, which is the notice in terms of Rule 4 of the Rules Regulating Procedures. And the note that notified the respondent about the case that he had come to meet said, and I quote, "It is alleged that the facts set out in Annex A to this notice constitute a complaint of gross misconduct against you," close quote. And Annex A made reference to the complaint by the complainant, Ms. Mengo, which is dated 12 January 2023, I'm sorry. And the notice further notified the respondent that, quote, a concise summary of the evidence and any other information which substantiates the complaint against you is set out in Annexure B. And what does Annexure B state? It states as follows. The heading there is concise summary of evidence. It is alleged that between June 2021 and November 2022, you sexually harassed the complainant, Ms. Andiswa Mengo, by A, sending her on WhatsApp messaging service unwelcomed, unwanted messages of a sexual nature, as well as crude pictures. And lastly, B, behaving indecently towards her in your office at the High Court in Umtata, close quote. The contents of Annexure B, of course, mirror the JCC's summation of Ms. Mengo's complaint. And at paragraph 1, the JCC summarized the case made by Ms. Mengo in her complaint in the following terms. And I quote, she, Ms. Mengo, alleged that between June 2021 and November 2022, the judge president sexually harassed her by A, sending her on WhatsApp messaging service unwelcome, unwanted messages of a sexual nature and crude pictures, B, behaving indecently towards her in his office. Similarly, the similarity of the words in the JCC's summation and the terms of Annexure B is stuck for a reason, of course. This is hardly surprising. After a thorough examination of the parties' assertions that Ms. Mengo's complaint and the respondent's response, the JCC identified the issues which it was called upon to determine in the following way, quote, the inquiry at this stage is whether the judge president's conduct prima facie constitutes sexual harassment. This is at paragraph 21 of this. And it went further to make itself clearer at paragraph 24. The JCC then identified the issue before it as follows, quote, as a prelude to considering the complaint before us, it is common cause that the judge president made sexual advances to Ms. A.M. I think it's Ms. Mengo. The question is whether those were unwanted, and if so, whether the JP knew or ought to reasonably have known that they were unwanted. Of course, the narrow campus of the inquiry is much clearer and perspicuous by the ratio of the decision to recommend the referral to this tribunal, which was made at paragraph 27 by the JCC. It says, the contours of sexual harassment are complex, and in this case, they would be best resolved in an investigation where the parties' versions would be tested through cross-examination and possibly expert evidence. For example, this committee is not equipped to determine whether certain pictures were downloaded from the internet, as alleged by the president, or sent from the judge president, as alleged by Ms. A.M. The most appropriate conclusion is to refer all those aspects, including the contents of acting deputy judge president's affidavit, for further investigation. Now, this, of course, this summation accords with what we would call a liberal reading of Ms. Mengo's complaint as set out in Annexure A. Therefore, this is the case that is to be determined, and this is the case that the respondent was to meet, so that it's not mischaracterized. And of course, my parting shot in this is that while there are issues that are disputed, and there are facts that are disputed, it will be revealed through his own testimony, the conversations that he had. And those will become clearer because they are uncontested. As he testifies, he will demonstrate to the tribunal which things in the entire accusations did not happen, which pictures are alleged to have been sent by him, but he didn't. The rest of the evidence is factual and has been led, and experts have appeared before this tribunal. And to make this entire case and to give the facts that support his version of events, the following witnesses will be called. The first one, and I would like to give the tribunal the entire list once and for all. And in fact, I'm giving it in the order in which they will come. The first one will be Ms. Zinhle Nqayi. The second one will be Ms. Unathi Sogoni. The third one will be Dr. Mello. And the last one will be the judge president himself, the respondent. And at this point, Chair, I would like to hand over to Mr. Madonsela, who will deal with the first three witnesses that I've mentioned, and I'll hand over to him as we start our evidence. Thank you, Chair.